No, please, madam. May the function of the petitioner victim mention item number 47 and 48, madam. And it will be taken up with the last part of June, madam. Yeah, AG is out of station today and because it's regarding challenge of the certain section of the GMC Act, madam.
Okay. Who is appearing for the other side?
Petitioner.
Give us some time when.
Let it be on the last week of June, madam. Let it be on.
Why in June?
He will be out
Because that will be a time just before vacation.
Then let it be out after vacation, madam.
And the prayer of the council for the parties less than the third week of July. On a date to be fixed by the registry. After second week of July, on a date to be fixed by the registry.
May please, Your Lordship. I beg to mention for item number 21, Your Lordship, of the list. Can you be passed over for the day, Your Lordship?
Wait for some time. We'll pass on this order. Wait for some.
My lord, I beg to mention item number 11, my lord. My lord, in this case, my lord, I don't have some document, but already LCR is there, my lord. So I want to check the LCR, my lord. So call it for a day, my lord.
We'll pass necessary order. Don't worry.
My lord.
May I please, Your Lordship? My lord, this matrimonial appeal may kindly be listed on Tuesday next. I appear for the respondent wife. The order of the family court is in my favor. Husband has been directed to take me back to my matrimonial home. In spite of that clear direction, he is not complying with the order. His application for stay has been rejected by this honorable court. So there is some urgency in the matter. On Tuesday next, Lordship.
Just a minute. Let us see.
Restitution.
It will come for order or admission.
Actually, it was for hearing. It was last heard on it was listed on 15/6/23. But due to paucity of time, the matter could not be heard.
Tuesday. There are
Obliged.
certain items fixed. Let us see. Okay.
Obliged.
We'll have
Obliged,
it on
Lordship.
28. Yes.
Lordship. Kindly see the page number 25 of Annexure 7, Your Lordship, in order. Page number 25, Annexure 7, Your Lordship, in order. Your Lordship. Second para, Your Lordship. The respondent was called up to appear and prove if he claimed to be a not foreigner of the post 25th March 1971 stream. The respondent appeared, filed written statement claiming to be citizen of India, but failed to adduce evidence to prove that he was not a foreigner as alleged, as required under Section 9 of the Foreigners Act 1946. I therefore give my opinion that the respondent Iman Ali is a foreigner of post 25th March 1971 stream from Bangladesh, Your Lordship. 65 voter list, your lordship. I can produce documents, your lordship. 1965 voter list containing the names of parents of the petitioner, your lordship. 65 voter list. Annex number 1, your lordship. Next number 3, your lordship, 1970 voter list containing the name of father. In 1989 voter list, your lordship, the name of father, parents of the petitioner, father, mother, and petitioner's names appear in the voter list, where the name of his father has shown Fakir Ali against his name instead of Fazar Ali. No shifting is there, your lordship. WS was filed, your lordship. At page
How you
22.
have filed? What is the
WS,
filing number?
your lordship.
How you are sure that it was filed?
WS was filed on 6 March 2006. At page 23.
Lordship. Lordship had on the last date heard the matter and fixed for necessary orders today because they wanted to place some decisions. The last order reflects it, Lordship.
Fresh sums may be given, your lordship, to reduce oral and documentary evidences.
I believe so. Nothing. Unnecessary. Ms. Verma,
Yes, Lord.
page number 25.
Order dated 5/6/2008.
That's right. It is an admitted position that the written statement was filed,
Yes, Lordship.
but did not reduce evidence.
But no evidence.
But what we found that the tribunal did not discuss whatever had been made in the evidence. There was similar matter yesterday. But the worst part is that the petitioner was fully aware about his problem. Right? Because he was represented by his counsel. And from the record, what we could see that he was represented by his counsel up to 11th of July 2007.
Yes, Lord.
But thereafter, petitioner did not appear before the trial, not to his name. And the tribunal on after 11/7/2007
Obtained the certified copy only in the year 17, Lordship.
on 10th day, after granting time on 9 occasions. On 10th day, he passed that order. The tribunal passed the order. On 5th of June 2008. But for that reason, one part. Second part is the tribunal did not discuss.
Lordship, in the written statement, has he given some documents? Lordship has the records?
That
Nothing.
could have been recorded by the tribunal. Normally, it's a
It
quasi-judicial.
reflects in the order, Lordship.
That's true.
It reflects,
To reduce evidence, that is
Yes.
reflected, no doubt. But think whatever he stated, only 2 lines could have been discussed, which the tribunal did not. Will impose cost upon the petitioner because of his conduct.
delay in
That's right.
latches also, Lordship, will take into
For everything.
consideration.
Very poor person.
And will remand back the matter to the tribunal. This is from Juria. Juria will be in Nagaon district only.
Yes, Lordship.
Yesterday we have imposed cost of 10,000, same amount, it will be deposited before the district legal services secretary, Nagaon, on or before 20th. And along with the
20th.
written receipt appear before the tribunal on 24th.
20. 20.
Hmm? 26th, na 20th June, she will deposit the money.
On or before 20th June,
Hmm.
she will deposit 10,000 rupees
Mhm.
cost. Failure on her part, it will be dismissed. On the 24th itself, she will submit her written evidence in affidavit.
You have to appear on 24th June
We'll clarify in the order.
with your WS.
Just a minute.
That, that will remand back to court. लिखी दिया.
You are Miss A. Begum. Ten thousand. Or the deposited secretary, district legal service. On or before 20. They took it out. Very necessary. Written basic public activity. That. Appeal to the private account on 24. 24. 35 written receipt in origin was committed to the secretary. The same state that itself by 124. The petition shall submit his written evidence in along with the relevant document. Plus certified copy of the public. He wants to prove it. That's it. Yeah. Okay.
May I please your lordship? At page number 57, we have annexed our earlier order in one earlier reference in which we
By order dated 18/12/2019. the records of case number FT within bracket C 278/2015 as well as the records of case number FT within bracket C 324/2015 এই আগতে FTC লিখিতা ব্ৰেকেটৰ ভিতৰত State of Assam versus Kritibas Haldar KRITIPASH Haldar HALDER and others. As well as Roman to Kritibas, case number FT324/2015, State of Assam versus Narayan Haldar and others. We call for from the Foreigners Tribunal number 3, Morigaon, Assam. Further, by the said order dated 18/12/2019, court also called for the records of FT case number 597/1988 within bracket State of Assam versus Kritibas Haldar and others from the office of the Foreigners Tribunal, Nagaon. Office note dated 16/5/2024 reflects that the record of FT case number 597/1988 within bracket Kritibas Haldar and others versus only State versus Kritibas Haldar and others has not yet been received by the registry. Take your seats. Ms. Verma,
Yes, Lordship.
uh, three records were called for by the court. This particular record where it was decided is number 57A, the petition. This was by the Fairness Tribunal, Nagaon. Now, since Morigaon, this case was initiated in 1988, the order was of 21st of January 1992. It may so happen, since the procedure is from Morigaon, the records of the case might have been transferred to Morigaon. We do not know at this moment. Because record reveals that notice was given to all the three tribunals. So other two records they have received,
And we're not paid.
but this particular record, the third record,
We can send a reminder, Lordship, for the records.
so probably we should also issue a reminder to the Morigaon.
But we'll have
Both
to know
SP
the
border Morigaon and SP border Nagaon both.
case numbers will have to
We'll be
be,
given everything.
yes, Lordship.
The The petitioner is in interim protection and interim bail since 18/12/2019. Issue reminder. Tara, what is it? It is seen from the order dated 21/01/1992, passed by learned Fairness Tribunal, Nagaon, in F.T. case number 597 of 1988. That the petitioners are from village Malpota, Bafanaghat, BASNNA, GHAT, under Morigaon Police Station of erstwhile district Nagaon and presently Morigaon. NPAPO, it is to Malpota. Activity in Italy. No, legal. Actual analysis, city of like district erstwhile Nagaon and presently Morigaon. Registry shall issue reminder to the Foreigners Tribunal, Nagaon, as well as Morigaon, for the records of said FT case number 597 of 1988 that was decided on 21/01/1992 by the Foreigners Tribunal, Nagaon. Registry shall also issue reminder or communicate this order to the Deputy Commissioner, Nagaon, as well as Deputy Commissioner, Morigaon, and further the Superintendent of Police, Border, Nagaon, and Superintendent of Police, Border, for their necessary. A copy of this order also be issued to Ms. A. Verma, Standing Counsel, Home Department, Assam, as well as Mr. P. Sharma, Additional Senior Government Advocate, Assam, for their honored communication to the Foreigners Tribunal, Nagaon, Foreigners Tribunal, Morigaon, Superintendent of Police, Border, Nagaon, and numerical and Superintendent of Police, Border, Morigaon, their A&D, Deputy Commissioner, Nagaon, and Deputy Commissioner, Morigaon, respectively. List on 19th of June
Highly obliged.
Lordships, this is a contested case, Lordship, and the proceeding was earlier declared to be an Indian in the year 2012. And thereafter, a fresh notice was issued to her. She again appeared, contested, and on this occasion, she has been declared a foreigner. The impugn order is a page 99, Lordship. And Lordship,
Earlier order,
the earlier order is a page 57, Lordship. Earlier order, page 57. And Annex of 5. And page 99 is the impugned one. Page 90, Annex 25. Lordship, I would like to draw your Lordship's kind attention to page number 99, Lordship. Here, it may be seen that reference IMDT case number 8266 and the FT case number 462, the second line, Lordship. First line is the fresh case number 16 DHL 2021, FT case number 462, indicating that this case has arisen from 462, and 462 has been started on the basis of 8266. And now, if we turn to page number 57, Lordship, kindly. FT case number 462 2011, page number 57, SP inquiry number 8266. So, Lordship, in this case, what happened? From the reference number 8266, earlier 462 FT case number was registered, decided, and disposed of. Thereafter, again, on this reference, same reference, this fresh case has been instituted. So, this is an anomaly, Lordship. Once a case is registered on the basis of a reference, that reference cannot be taken again, Lordship. Because after passing of this order, the court becomes functus officio, Lordship. This is not different reference, Lordship. On one reference, one case is
see, there is a reason behind that.
Lordship.
Please come to page number 100.
Lordship, 100.
If you read the first paragraph itself, you will see
Lordship. Originally, this case was forwarded by the Superintendent of Police, SP for short, Mangaldev White FT, for case number 16 of 2021, reference IMDT case number 8266. So, this finding is perverse, Lordship.
this.
In view of the,
Read it. Don't
in
just
view of
look
what has been recorded in the first page, Lordship.
first paragraph, you just read fully.
Yes, Lordship. Originally, this case was forwarded by Superintendent of Police, Mangaldev White FT4 case number 16 of 2021, reference so-and-so, 8266, expressing doubt about the nationality of the OP, namely Zaina Khatun, wife of so-and-so Assam, with a prayer to decide as to whether the OP is or not an illegal migrant. Subsequently, in view of WT message, this case was transferred to this tribunal
So
for decision.
definitely there has to be something in between.
No,
Later
sir.
records come, we'll see to that.
Lordship, the case record of both the cases may be called for, Lordship, and in the meanwhile, I may be
That
protected.
we
Lordship.
do. What thing is this? That is why there is some specific direction. That is why the tribunal took up the matter.
Lordship,
Heard Mr. Z Hussain. Counsel appearing for a petition. Anyone for Union of India?
Union.
Miss. A. Verma, standing counsel only person for the respondent to
Coming to next slide,
Six.
dear sir. Item 4.
fully. Election Commissioner with the respondent. Three. P. Sharma. In a reference being made by the Superintendent of Police ordered Mongol by FT-4 case number 16 of the 2021. Comma. Reference IMDT case number 826698. And in terms of the W2 messages of the government, comma, the Furnace Tribunal, Ranit Furnace Tribunal, Port Dorong, Mongoldo, in FT Port case number 16 of the DHL of 2021. By the impugn order dated 17/10/2023. After hearing the parties and considering the evidence adduced by the petitioner, who find her to be a foreigner under the Foreigners Act 1946, who had illegally entered into the territory of India from the specified territory of Bangladesh. Illegally on or after 25/03/1971. It is satisfied with the said opinion. Dated 17/03/2021. Petitioner has filed this. It is also contended by the petitioner that earlier in the same SP inquiry number 8266 of 98 of the Superintendent of Police, Dorong, Lanet Furnace Tribunal, Dorong, Mongoldo, in FT case number 462 of 2011. After hearing the parties and considering the evidence adduced by her, by opinion dated 07/06/2012, declared her to be and appoint her not a foreigner, not to be a foreign national, not a foreign national. Issue rule returnable by 6 weeks. Call for the record of the referee. Furnace Tribunal, Dorong, relating to application number 462 of 2011. Bucket to the court. As the but the impugn order is a petition and has been declared to be foreign under the Foreign Act. It shall appeal before the Superintendent of Police order Dorong on or before 12th of June.
Interim
Not
Wikipedia.
Petitioner shall take steps. Service of the বাকি যেটা ছাত্রবলী as for number 4, 1 of Sarpur 4 of raise the post on or before Monday. After the recording.
All right.
Actually, Lord,
Yes, Mr. Ramdev.
my lord, The petitioner exhibited 13 numbers of documents, including the voter list of 1966, 71, 89, and my lord, her name has been recorded in the voter list of 1985, 1989, and till today, my lord. So lordship will find the interim opinion at case 81.
Please take your seat, Mr. Ahmed.
My lord.
Mention it. Have to mention. Did I mention it? Thank you. When you try for 15 engineers.
Heard Mr. Rassi Ahmed for the petition. By the impugn opinion, dated 10/05/2023. Learned Foreigners Tribunal, Assam, Borpeta 11. At Sorpo. Appoint the petitioner to be a foreigner under the Foreigners Act 1946 by the entire people under the Indian Citizenship. In my opinion, we could not test the budget ordinary ever deemed it or that she was going from getting the relevant for that. Failed to prove her citizenship. Agreed by the said opinion. They get certain petition as filed this way. Before we proceed further, we like to examine the records of FT case number 1589 of 2017, where the opinion dated 10/05/2023 was passed by the Land Finance Tribunal for Peta Island, Sorpo, Kolkata Airport. This is the matter for motion immediately. That's it.
My lord, in the meantime, my lord, he may be
The interim
protected.
priority petitioner shall be considered
Yes, be protected.
on perusal of the relevant records of the concerned fairness tribunal.
Oblige me.
May I please, Your Lordship? My lord, assuming the opinion, still, my lord, 6/9/2018, my lord, passed by Learned Fairness Tribunal, Golpara, 5th. Petitioner has filed this petition, my lord.
Hmm.
Interim opinion is at page, my lord, 71, starts from 71, my lord.
Hmm.
Yes.
The petitioner has tried to establish his linkage to his father, parents, my lord, whose names are there in the voter list of, my lord, 1971. Originally, they were from Baghdad of Barpeta district, my lord. Grandparents' name respectively Lalmuddin and Soleiman Bewa. They were the voters of 1966 and 1970 of number 52 Bagbor LSC, my lord. Petitioner's father is Sonaullah and mother is Sukuran Nessa. Their names appeared in the voter list of 1971 of Bagbor LSC, my lord. Due to erosion, my lord, they have shifted their residence from Bagbor to Golpara. And while they tried to enumerate their name in the voter list of Golpara, my lord, mother, elder sister, and the petitioner has been detected as doubtful voter. And petitioner's elder sister was also proceeded, my lord. An expertise proceeding was initiated against her. She was taken into custody. From detention camp, she has filed a writ petition, wherefrom she was allowed to contest. Accordingly, she has contested. And on perusal of the documents, my lord, she has been declared as not foreigner. Right annexa S, my lord. Same set of documents has been relied by the present petitioner, but present petitioner's case was not considered by the same tribunal, same member, my lord. And he has been declared as a foreigner of post 71. And in both the proceedings, my lord, mother of the present petitioner has adduced her evidence. She was duly crossed, but her cross was not considered while discussing in the impugned opinion. Petitioner's mother appeared in the proceeding of her daughter, my lord, who is my elder sister. And I have categorically stated about my parents in my written statement, including the name of my elder sister who has been declared as a not foreigner.
Please take your seat. Yes, Mr. Das shows the links. How you have proved your link. Which is your first link document to connect your parents?
My lord, that is the voter list of 2005, my lord, number 37, Gwalpara East LAC, which is at page 33, annexure H, my lord. My mother's name is there.
Is it a certified copy? Have you proved it before the tribunal?
My lord, exhibits. My lord. Exhibit G, my lord, certified copy.
Exhibit Z.
Is a certified copy voter list of 1997, village zero sir in the name of parents and elder sister of the, no, my lord. What happens here, my lord? I was engaged as a domestic help in the Gwalpara district, and my remaining family members were resided at Bagbor, my lord.
No, first of all, you are projecting your parents, right?
My lord,
You are projecting your parents, and according to you, your parents lived in India from 1966 or prior to that. What is it?
71.
How you have linked yourself with your parents?
My mother came and adduced the evidence.
Adducing evidence, anybody can get in. Say to prove that I am an Indian citizen.
My lord.
Tomorrow, anybody can come say, anybody of you can come say, I know him. Anybody, anyone elder to me will come say, I know him, he is the Indian citizen. Will that do? Or some documentary evidence will be required?
My lord, in the case of my elder sister, also my mother came and adduced her evidence. That was considered, my lord.
That is, doesn't mean that we have to look at here in that manner. You have to prove some contemporaneous evidence. What is that evidence? By which did your mother prove the link between you and her through any such record, any such document, any voter list?
There is no such documentary evidence, my lord, but my lord,
Then how you see, how do you prove that you are the son and of A and B? How you have proved that?
yes, admittedly, my lord, there is no such document because he is an illiterate person, and my instruction is
Prove
that
that your parents' name, your projected parents' names are there in the voter list of 1966, 70, 70. But how you have linked yourself with those projected parents?
there is no such link document, my lord. But I want to submit, my lord, that my elder sister has also stated in her written statement that I am her younger brother, my lord.
That has to be proved by some
Yes,
document. Right?
there is no such documentary evidence, my lord. But during the proceeding of my elder sister, that was considered. That Yusuf Ali is,
Right? We have to-
Samiran's-
She might have said that you are her brother, but to prove her citizenship, she might have proved her link with someone of your parents.
yes, my lord. There is no such link document in terms of voter list or any other certificate, etc., my lord.
No, with regard to your sister, we are not concerned. We are concerned only with you.
Yes, my lord.
Kindly show any such particular document to link yourself with your parents.
No, my lord, there is no such document. Only my elder sister has stated that I am her brother in her written statement as well as evidence. And that part was considered by the same tribunal, my lord.
Tribunal considered in that case, she also, when there was a case against her, there she relied upon a particular evidence that she is the daughter of Mr.
So now what?
Mrs. B.
Yes,
She might have proved something in that before that tribunal or the same tribunal.
Yes.
Her link with her projected parents.
yes, my lord. In this particular case, there is no such link document, my lord. That's because I was engaged as a domestic help in Gwalpara, my lord, and they were resided at Bagbor. That is categorically stated in my written statement, and that part was not considered in the imperial opinion. Not a single whisper in the opinion that whether I was there or not. And my respectful submission is that same set of documents, my lord, relied,
See, basically, Mr. Dahal, it has to be a connecting document to
my
prove.
lord. There is no such document,
That's what we're asking.
only the statement of my mother and elder sister.
See, basically, in that, in case of your sister,
Samiran, my lord.
in case of your sister, what she had done, your projected sister, that she had adduced evidence or exhibited documents of voter list of 1966, 1970. Right?
My lord.
And showing two names. Her projected parents.
Parents. Yes, because she was
One
residing
is
with her parents.
Sonaullah
And Sukuran Nessa.
and is
Sukuran Nessa.
Sakurun Nessa. Okay. Sonaullah was there in 1966.
Along with his father, my lord, Lalmuddin
Then
and Solomon Dewa.
Sonaullah was there 1970.
In 71 also there, my lord.
Then Sonaullah was there in 1985.
Yes, because I was resided here in Gwalpara and they were resided at Bagbor, Borpeta, my lord. That's why my name is not appeared there. And subsequently, they will also came
Now,
here. And all
she
the,
also adduced
my lord,
exhibited document that her name figured along with her parents in the voter list of 1989. Right. And that is why probably the tribunal accepted her to be an Indian citizen because she could prove her link with her parents. And the tribunal came to a finding that her parents were available in India during that period. That is why we are asking you, where is your link document with your parents? Now
there
you
is-
said you do not have any link document.
no, my lord, there is no such living document, my lord. But my lord, I want to draw your lordship attention, my lord, my mother, elder sister, and myself, and one Abdul Mazid, all of them were shifted from Bagbor to Gwalpara. All of them were declared as D, my lord. At page 34, Annexure 8, Assamese version, my lord.
Mm.
My mother was also termed as a D voter, my lord.
Mm.
My elder sister was also termed as a D voter.
Mm.
But now I cannot say whether any reference was initiated against my mother or not. But that Samiran Nessa, he was termed as a D voter, my lord, whose name was there in the Bagbor. When they shifted from Bagbor to Gwalpara, and their name appeared in the number 37 Gwalpara East LAC, Samiran Nessa was termed as a D voter, my lord, and reference was initiated against her. Subsequently, that Samiran Nessa was declared as a not foreigner, whose name was there, whose name is there in the Bagbor LAC. And as I was engaged in the domestic help in Gwalpara, so my name is not there. I have categorically stated in my written statement, but that are not considered, my lord, in the opinion. When Samiran, my mother, shifted from Bagbor to Gwalpara, they were detected as doubtful voter, and reference was initiated against them in the Gwalpara district, my lord. As soon as she adduced her evidence, documentary evidence that she was a voter of Bagbor LAC, she was declared as a not foreigner. And my mother came in both the cases, my lord, in my cases as well as in my sister's elder sister's cases. My mother's statement was considered in her case, but not considered in my case, my lord. আছে, দুটো আছে, পাঁচশটো। And in the opinion passed in my elder sister's case, it was stated that though there are some discrepancies, that were also overlooked, my lord, by the learned tribunal below. It was there in the opinion at annexure S, my lord. Opinion passed in my elder sister's case. And they had to shift that, my lord, due to erosion of Brahmaputra River, my lord. And my parents, my mother and elder sister, they are still cast their vote in Bagbor, my lord. So, And in the present case, as well as in my elder sister's case, my lord, notices were not properly served. As a result, thereof, my lord, in both the cases, ex parte proceedings was initiated. My elder sister was taken into custody and kept her in detention camp, my lord. From their detention camp, she has preferred a writ petition. Allowing her writ petition, she was allowed to contest, and accordingly, she has contested. And she has been termed as a not foreigner, my lord, by learned tribunal below. And I was declared as a foreigner. In my case also, my lord, ex parte proceeding was initiated. However, later on, he was allowed to participate by filing WS. He has accordingly filed his WS and participated in the proceeding, relying on same set of documents. And within a gap of 2 or 3 months, my lord, both the opinions were passed by the same member of the same tribunal. এই ভাগতে দি উজু কৰিছে
Yes, Mr. Sharma.
Lordship, in voter list relied by the petitioner Lordship, in everywhere there is a discrepancy. Lordship will see 1966 voter list. It is of village Muamari, where Sunaullah projected father's name appeared and his grandfather's name was stated as Lalmuddin Lordship. And in WS also, he specifically stated that my grandfather name is Lalmuddin Lordship. Then Lordship 1971 voter, 1970 voter list Lordship, it is same village, same thing. There is no discrepancy Lordship. Then Lordship 1971, it is a Kopatuli Nonke, and here his grandfather's name become Lal Mahmud instead of Lal Muddin Lordship. And in WS Lordship, Proceedee never stated that Lal Mahmud and Lal Muddin are same and one person Lordship. Then Lordship, again Lordship 1985 voter list Lordship, it is of different village, Ujidar Sir, where one Sunaullah's name appeared Lordship, where his father's name appeared as Lasrom. So everywhere Lordship there is a discrepancy, and regarding that Lordship, law has already been settled Lordship. If petitioner relied on a document Lordship, that should be appreciated as a whole. Proceedee cannot rely on those part which is in his favor and cannot accept those part which is cannot. Yes, Lordship. Proceedee cannot accept those part which is in his favor and cannot overlook those part which is against him, Lordship. Then Lordship, Lordship, here Lordship, Proceedee apparently failed to establish his link with his projected father. Only remaining is that oral evidence of his mother and Lordship, his elder sister, Lordship, which is not acceptable in the law, Lordship. Where Lordship, I am relying this Vijay Das case, Lordship, where it was stated that Lordship, 2018 3 GLT 118. Para 17 Lordship, where it is stated that it is tried that mere filing of written statement or oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceeding by adducing documentary evidence which are admissible and relevant. The two documents filed by the petitioner were not proved in any manner whatsoever, and therefore the assertion of the petitioner that being a son of so-and-so who was a citizen of India was therefore citizen of India was not proved. Lordship, apart from that, Lordship, another two citation was there, Lordship, in WPC in 1900/2019, Noor Begum versus Union of India, where it was stated that Para 6 Lordship, statement of DW2 Johrun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in the absence of any documents showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony of DW2 alone, since any documentary support cannot be treated as sufficient to prove the linkage or help the cause of the petitioner. Surprisingly, the petitioner failed to produce a single voter list in her name even until the age of 50 years. We would reiterate that in a proceeding under Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is solely insignificant. Oral testimony alone is no proof of citizenship. Then, Lordship, regarding oral testimony of father in WPC 4020 of 2017, Lordship, it was the same thing has been reiterated, Lordship. Statement of DW to Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in absence of any documents showing his relationship to the petitioner. In this, we would observe that in a proceeding under the Foreigners Act 1946 and the Foreigners Tribunals Order 1964, the evidentiary value of oral testimony without support of documentary evidence is solely insignificant. Oral testimony alone is no proof of citizenship. The evidence of DW2 thus falls short of being considered as cogent, reliable, and admissible evidence, so much so to establish linkage of the petitioner to him. So, Lordship.
Mr. Sharma,
Yes, Lordship.
it's a clear admission of the petitioner in his written statement itself
Lordship.
that from his childhood he was in a different place at Gwalpara, and then he did not take any step to incorporate his name in the voter list.
Lordship.
That is his own statement. The written statement he has categorically stated. Now, though he was at Uzidor Church,
Yes, Lordship.
He was born at Ujiro, sir, my lord.
then that is his one statement. In the written statement, he has also stated that he was at Gwalpara for many years since his childhood,
Yes, sir.
prior to shifting to village Monacocha. He was at Monacocha. Then thereafter from Monacocha, he again shifted to
Gopalpur.
another village in district of Gwalpara itself.
Lordship.
Gopalnagar.
Now, as you have just read this judgment, we are making a statement in the written statement or some evidence adduced by somebody on the oral test.
Okay.
The petitioner's case cannot be considered.
Yes.
Now just tell us one thing. The petitioner relied on the decision of his sister,
Yes, Lordship.
who according to him was also declared as a devoter. But the tribunal considered her case. Now, the tribunal, before the tribunal, the same tribunal,
Hmm.
the sister of the petitioner, projected sister, she could show a few voter lists along with her mother and father.
Yes, Lord.
Okay. But in her written statement before the tribunal, the projected sister of the petitioner stated
My name, my lord.
that
Your name कैसे है? उषा वाली her sister बगैर बोले कैसे? बंदे से.
Ushrab Ali, Maqbul Hussain, Altaf Hussain, Ajibur Rahman,
Hmm.
and
मम्मी
one Momirun Nessa who expired is her brothers and sisters.
Hmm.
She stated. Now,
what else is required? What document is required? কতজন মেম্বার এলিজিবল কনসিডার করবে মহিলা কনসিডার করবে এটা তো ডিটেনশন সেন্টার ফাইল করেছে তাই
In her evidence before the court, during cross, she also stated that
কোশ্চেন আইডি ওকে
she has 4 brothers and 2 sisters.
Yes, come.
Now here she said Yusuf Ali. Right?
Yes.
Projected mother also said that he is her son. So from those evidence, the projected sister, who has been declared to be an Indian or not a foreigner, and his projected mother, whether petitioner can be considered to be not a foreigner.
Only statement is not enough, Lordship.
Yes, Mr. Sharma.
Lordship, only statement is not enough. And Lordship, what opinion has passed in case of elder sister, Lordship? Ji- This- Although there are so many discrepancies, Lordship, where Lordship in 1966 voter list and 1970 voter list, those who are appears in those voter list in 1971 voter list, other persons names are not reflected in 1971 voter list.
We cannot go to that judgment.
Yes. Not necessarily.
We are not on that judgment. That is up to you to decide. We are not. The thing is this showing the judgment whether the petitioner will be able to prove his nationality. That is the issue.
No, Lord.
Why?
Because these are only statements. oral statement is not enough, Lordship. Without,
What is required?
without supporting documentary evidence, Lordship,
What kind of documentary is required?
Lordship, and Lordship,
They have said,
some, yes,
they have said he is my brother.
some
he is
evidence,
my
Lordship,
son.
it is required to prove that, Lordship, Proceed is staying at Gwalpara from her childhood, Lordship. From that place, some evidence he could collect, Lordship. Lordship, some elderly person from where,
Same set of documents were relied, my lord, in my elder sister's case.
That is why you are saying.
Unfortunately, that
in
is not
case,
considered in my case. my
lack
lord.
of
The
proper,
And I have admittedly
Eh,
stated,
your
state has not
projected sister, your
discarded my
projected
evidence.
sister could place certain voter list before the tribunal where her names figured with Sonaullah and Tamarin Nessa, right? Or your mother, projected mother. Right?
And
But
that.
Mr. Yudas, counsel appearing for the petitioner and Mr. G. Sharma, standing counsel from Department Assam. For the response number 2. 6. Also heard H. Kuri, standing counsel election commission India for the response number 3. And Mr. P. Sharma, standing counsel from government, additional senior government at Assam for the response number 5. There is the records of application number FT/5/191/MO/17. Union of India, flat state of Assam versus Utsav USAB, within bracket USUP, bracket Gozali. As well as the record of application number FT
Page 78. my lord. It is. That is it. Oh, I can hold the document on the record.
/5/193. /MO/17. Union of India versus State of Assam. Sorry, Union of India / State of Assam versus Samiran Nessa. Both decided by the Foreigners Tribunal 5th at Valpara, disposed of on 06/09/2018 and 24/07/2018 respectively. All four by the court by order dated 09/01/2019. Arguments concluded, order reserved.
Obligement.
Notice in this case was issued on 17/5/2017. Registry also received the relevant records from the Foreigners Tribunal for Valpara. It was called for by order dated 17/5/2017. Petitioner is in interim protection and interim bail since 17/5/2017. Don't write check. Register shall let them have. The petitioner shall appear before the Superintendent of Police Board for honor before 14th of June. Capturing notice in this case was issued in 17/5/2017.
May I
They
please
received the
lordship?
relevant records from the foreigners tribunal court to bring that was called for by order dated interim protection, interim bail in 17/5/2017. Some more. To appear before superintendent order to bring on the report. Same day. Capturing hard. Notice in this case was issued on 26/5/2017. 11 records. from-
May I please your lordship? Item number 7. My lord, the matter may be adjourned for the day.
Received from foreigners tribunal number 8 for the interim protection, interim bail. 26/05/2017. Rule hearing. We are before Superintendent of Police Border Barpeta. Honor court. Capturing hard. Cheek.
May I please, your lordship? My lord, in this case, my lord, reference is against the petition number 1 only, my lord. Regarding the other petitioners, my lord, there was no reference.
The notice in this case was issued on 31/05/2017. Received the record from the foreigners tribunal 3rd Morigao. That was called for by order 31/05/2017. Interim protection, interim bail since 31/05/2017. The petition number 1, Asan Ali, alias Muhammad Ashan Ali, son of Abdul Jabbar, shall appear before the Superintendent of Police Board of Morigao on of 14, capturing case. Notice in this case was issued on 31/5/2017. Registry received the relevant record from foreigners tribunal number 1, Bombay. That was called for by order dated such. Interim protection, interim bail 31/5/2017. Shall appear before the Superintendent of Police Board of Bombay on of hearing 52. Notice in this case was issued on P6/2017. Received the record from foreigners tribunal for Peta 11 at Soroko. Interim protection, interim bail 2/6/2017. Rule hearing to appear before the to appear before Superintendent of Police Border Barpeta on or before capturing her.
Avlai manner.
Notice in this case was issued on 02/06/2017. If they receive the relevant records from foreigner tribunal, court number 7, Lanka, Kotai, records for by order dated 02/06/2017. Interim protection, interim date 2/6/2017. Rule hearing appear before Superintendent of Police Border, Ojai. Ojai for capturing keys. Service of condition. Notice in this case was issued 12/6/2017. Record received from the Foreigners Tribunal, first Lakhimpur, not Lakhimpur. Call for by order dated 12/6/2017. Interim protection, interim date 12/6/2017. Appear before Superintendent of Police Order, Lakhimpur, on or before 14. For capturing his.
My lord, with due respect, my lord, may I be permitted to file an additional affidavit? There is an error with regard to translation, my lord, of a name. My lord.
Notice issued on 05/06/2017. Record received from Foreigners Tribunal, Borpeta 11, Sorbo. Interim protection, interim day 05/06/2017. Hearing rule, hearing to appear before the police border, Borpeta, for capturing her on or before 14th. Notice issued on 05/06/2017. Record received from Foreigners Tribunal, Borpeta 11, Sorbo. Interim protection, interim bill 5/6/2017. Rule hearing appear before Superintendent of Police Borpeta. Border water on or before 14th. Capturing his.
I'm always.
Notice issued on 7/6/2017. Received from records from Foreigners Tribunal, Nagaon, Court number 7 at Lanka, Kotai. Interim protection, interim bail in 7/6/2017. Rule hearing appear before Superintendent of Police Border, Kotai, on or before 14th for capturing his. Notice issued on 9/6/2017. Records received from Foreigners Tribunal,
16.
Court, Valpara. Interim protection, interim bail 9/6/2017. Rule hearing appear before Superintendent of Police Border, Valpara, on or before 14th for capturing his. Notice issued on 19/6/2017. Records received from Foreigners Tribunal 2nd, Borpeta. Interim protection. Nineteen six 2007. He was already taken into custody, so nothing has to be written. Rule hearing. Within the report.
May I have your lordship?
This is on 23/06/2017. Record received from Fairness Tribunal, Bongaigaon, number 2, Abhayapur. Interim protection, interim bail, 23/6/2017. Rule hearing to appear before Superintendent of Police Porter, Bongaigaon. On or before 14th, capturing her. She, Notice in application issued on 10/7/2017. Records received from Fairness Tribunal, Court, Ramagari, and Photographer. Interim protection, interim bail, 10/7/2017. Rule hearing to appear before Superintendent of Police Porter, Nalbari, on or before 14th, capturing. Notice issued on 14/7/2017. Records received from Fairness Tribunal, number 2, Gwalpara. Interim protection, interim bail, 14/7/2017. Rule hearing appear before Superintendent of Police Border, Gwalpara, on or before capturing case. Notice issued on 17/7/2007. Records received from Fairness Tribunal, 7th Tubri at Vilasiparaki. Interim protection, interim bail, 17/7/2017. Rule hearing to appear before Superintendent of Police Border, Tubri, on or before 14th, capturing her. Condition with.
It is your lordship. Lordship, in this, by this petition, the petitioner, FT case was registered against the petitioner bearing, FT case, number, FTDC case number 7112. And, the petitioner declared, to be, not to be a foreigner by the Foreigners Tribunal, second Tejpur. But subsequently another case was registered against the petitioner bearing, FT 6/21 2015 in the FT 6 Sonitpur Tejpur. And in the subsequent case, the petitioner was declared to be the foreigner by impugned order dated 8/5/2017, lordship. And he was arrested and sent to jail. And in a subsequent proceeding, the petitioner has exhibited voter list of 1966, showing the father's name and the order of the earlier proceedings, lordship, whereby he was declared not to be a foreigner. Despite of that, a petitioner was declared as a foreigner, and the impugned order was passed without any jurisdiction, lordship. Hence the petition, Your Honor. And in the case by this Honorable Guwahati High Court in Sitalal Mandal and others, and also was discussed about the
Mr. Verma, tell us once more. Whether this is there is any decision of the Honorable Supreme Court.
Lordship is, there are, decision of Abdul Quddus Lordship. Abdul Quddus versus Union of Indian Others, and
Amina Khatun's case.
Yes, yes, Lordship.
Now, in that case, whether it has been challenged before the Honorable Apex Court. Is there any order?
Yes. Earlier occasion, Lordship,
No, we want to know whether the order of the Amina Khatun decided on 19th of April 2018 is under challenge before the Honorable Apex Court.
yes, Lordship, but I think, Lordship, there was no stay order regarding that case, Lordship. Yeah. And
Are you able
Lordship,
to confirm it by Monday before us?
yes, Lordship. I think, Lordship, another case is pending and it was tagged with that case, Lordship. Amina Khatun case, Amiruddin Mozumdar versus Union of India. Lordship, this was special petition, civil diary number 41582 of 2018.
But
Oh, I will confirm and I will, otherwise, Lordship, on Thursday, another executive issue will be heard by your Lordship. Thursday, fifth the matter.
tomorrow is Thursday, next Thursday.
Next Thursday. Tomorrow is the holiday.
29.
BC Das case, Lordship. Yesterday he was appearing.
Notice in this case was issued on 17/7/2007. History already received the relevant report from the Foreigners Tribunal 6-4. Interim protection 17/7/2017. Was in first hearing. Already.
Otherwise, Lordship, earlier order passed by the tribunal, it was not a reason order, Lordship. And if it is not a reason order, Lordship, res judicata is not applicable, Lordship.
Why? Wherefore you are
Because-
saying it?
Because there, Lordship, there is a judgment, Lordship.
Hmm.
I will provide, Lordship.
Okay, you'll provide us. Next, call it next.
So I need to please to Jasmine's Lordship.
Give us the citation, madam.
Lordship, one, SSC 604 Lordship, the
Abdul
2019,
Quddus and
Abdul
Sital
Quddus.
Mandal, Lordship.
and Sital Mandal.
Have you read Abdul Quddus properly?
Lordship.
Have you read?
Lordship.
The next time when the matter will be in the hearing, if this bench is there, we'll ask you. Have you also read Chital Mandal?
Lordship.
Read properly. Yes. Next item.
Okay.
It is fixed on Thursday, Lordship.
No, we have issued rule. Give us those judgments. So what happened in the Amina Khatun's case?
Yes, sir.
Notice in this case was issued on 19/7/2017. Registry received the relevant records from the Finance Tribunal, Dashboard, First Sonit Court. Interim protection, interim bail. 19/7/2017. Rule hearing. Petitioner shall appear before Superintendent of Police Court. Sonit Court test. Honor. Capturing his condition. Notice in this case was issued on 26/7/2017. The registry already received the relevant records from Fairness Tribunal number 8, Walpara. Interim protection, interim bail, 26/7/2017. Rule hearing, appear before Superintendent of Police Court, Walpara. Honor before court for capturing her. She. This in this case was issued on 26/7/2017. The registry already received the relevant records from the Fairness Tribunal number 10, Dubri. Interim protection, interim bail, 26/7/2017. Issue rule, don't write secret. Issue rule and is the matter for hearing on a date to be fixed by the registry. Petitioner is on interim bail, interim protection. So interim protection, interim bail since 26/2007. Thereafter, in right hearing, petitioner shall appear before the Superintendent of Police Court to bring honor before 14 for capturing his.
May I
Notice in this case. was
Well,
issued
three, well, I have to appear before the box. Well, your lordship, kindly 3-2-1, please. I may be
30/08/2017. Registry already received the relevant records from the Foreigners Tribunal 9th Court. Petitioner is already interim protection and interim bail since 30/08/2017. Rule hearing. Petitioner shall appear before the Superintendent of Police Border Baksha. Honor before 14 for capturing her.
Hello.
Notice in this case was issued on 15/9/2017. Registry already received the relevant records from the Foreigners Tribunal, Nagaon, Court number 10, Sankatat Nagar, Gujarat. Interim protection, interim bail, 15/9/2017. Rule hearing to appear before Superintendent of Police Court, Gujarat. Honor before 14 for capturing his Mati conduct. Notice in this case was issued on 20/09/2017. Was received from Foreigners Tribunal number 4, Nalbari. Interim protection, interim 20/09/2017. Rule hearing to appear before Superintendent of Police Order Albury for capturing cases. Notice in this case was issued on 20/09/2017. Registry already received the relevant records from the Foreigners Tribunal number 9 now. Interim protection, interim bail, 20/09/2017. Rule hearing. To appear before Superintendent of Police Border Knock on or before 14th. Capturing her. Notice in this case was issued on 20/09/2017. They received the relevant records from the Foreigners Tribunal number 2 Kamrup at Boko. Interim protection, interim bail, 20/09/2017. Rule hearing to appear before Superintendent of Police Border Kamrup at Amingam on or before 14th. For capturing his notice in this case was issued on 20/09/2017. Registry already received the relevant records from Foreigners Tribunal number 2 from the interim protection, interim bail, 20/09/2017. Rule hearing to appear before Superintendent of Police Border Kamrup at Amingam on or before 14 for capturing his special authority 5889/2017. Separate order करके एक ही सकते हैं. Notice issued on 20/09/2017. Registry received the relevant records from the Foreigners Tribunal number 2 Kamrup, Boko. Interim protection, interim bail, 20/09. Rule hearing to appear before Superintendent of Police Border Kamrup at Amingam. सब में border होगा. Superintendent of Police कितना पूरा name भी बताया. On or before 14th. Capturing her. List along with application number 5887/2007. Okay. Notice in this case was issued on 21/09/2017. Registry already received the relevant records from the Foreigners Tribunal, Nagaon Court number 10, Sankadev Nagar, Pune. Interim protection, interim 21/09/2017. Hearing to appear before Superintendent of Police Border Hotai on or before 14 for capturing his.
I'm obliged.
Notice in this case was issued on 12/03/2018. Registry already received the relevant records from the Foreigners Tribunal, Kamrup Metro number 1, Guwahati. Interim protection, 12/03/2018. Rule hearing, बाकी condition देना जरूरत नहीं है. She was arrested. Notice was issued on 04/06/2018. Registry received the relevant records from the Foreigners Tribunal number 5th, Morigaon. Interim protection, interim bail. 4/6/2018. Rule hearing to appear before Foreigners Tribunal. Just a minute. Okay, sir. एक एक करके करेंगे। पहले वाला में 3552, 3522 2018. Notice was issued on 4/6/2018. Received the records from the Foreigners Tribunal 5th, Morigaon. Interim protection, interim bail. Rule hearing. Petitioner number 1, Masammat Hajara Khatu, shall appear before the Superintendent of Police, Border, Morigaon, on or before 14 for capturing her. Okay. This is one. The second case, 3218/2018. Notice in this case was issued on 23/05/2018. Registry already received the relevant records from the Foreigners Tribunal 5th, Morigaon. Interim protection, interim bail 23/05/2018. Rule hearing. Petition number 1 shall appear before Foreigners Tribunal. Sorry, Superintendent of Police, Border, Morigaon, on or before 14th. So, thank you. To be present. Rule is one. Rule is no problem. So issue rule करना है. It took a short time that that's 146 to each वाला में जो लिखते हैं WPC number 3218/2018 list along with WPC number 3522 of 2018.
46.
Notice in this case was issued on 21/01/2019. Registry, although they received the relevant records from the Foreigners Tribunal 5th Congo. Yeah. Petitioner is in interim protection since 21/01/2019. As the petitioner has been declared to be a foreigner under the Foreigners Act 1946. She shall appear before the Supreme Court Police Border, Kamrup, at a minimum of honor before 14th. But सब condition है उसमें बेल लगेगा, बेल नहीं, बेल का ऑर्डर बेल
May I please your lordship?
Notice in this case was issued on 21/01/2019. Registry already relieved the relevant case. The Foreigners Tribunal number 11 Borpeta. Petitioner is an interim protection since 21/01/2019. Hearing as by the impugned order dated 27/02/2018 passed with the land Foreigners Tribunal Borpeta number 11. The petitioner has been declared to be a foreigner under the Foreigners Act 1956. She shall appear before the Supreme Court Police. Just a minute. बक्सा भी हो सकता है रामदार बड़ी
It means if I file to go, it means say. Is often consecutive. Human number.
shall appear before the Supreme Court Police Border Borpeta before 14th. इसमें बेल लगेगा conviction.
Obliged, my lord.
Notice issued on 21/01/2019. Registry already received the relevant records from the Foreigners Tribunal Valpara. Interim protection 21/01/2019. Rule. Hearing. The petitioner has been declared to be a foreigner P and R very include all the API District Superintendent of Police Golpara honor before 14. Bill order there.
Deep privilege.
Your Lordship, respondent number 3 has filed an affidavit in opposition. Some time may be granted to file a reply.
What's your good name?
D. Chauhan, Your Lordship.
Counsel appearing for the petition. Naam likh kar do. Praise for some time. To file reply to the affidavit of the respondent number 3. Inspector General of Police Prison, Assam. It was filed on
My lord, 14/8/2023.
2023. Serving copy of the same the counsel for the petitioner itself on 14/8/2023. List of the 3 weeks in the meanwhile. The petitioner shall file their petitioners, their reply to the affidavit of the respondent number 3.
Obliged to Lord.
May it please your lordship. My lord, the issue here is, my lord, the termination of contractual employee, my lord. True, my lord.
Yes, please.
Yes, my lord, issue is in this writ appeal, my lord, regarding termination of a government contractual employee, my lord, under Panchayat and Rural Development Department. He was appointed on contractual basis, whether he is entitled for a notice or not, my lord. My lord, there are 2 different batches of judgments caused by a single judge, my lord. In one set of writ petitions, it was decided that the
What is
notice,
the appointment order?
my lord. Kindly come to page 29, my lord. Is the engagement order, my lord, on contractual basis?
By which order the service was extended?
My lord, there is an agreement that lordship will find at page 31. It was for a 1-year period, my lord. Thereafter, my lord, we are allowed to continue.
By which order?
My lord, there is no such order for our continuation, my lord. But my lord, this was not the ground of our termination, my lord.
Just tell us one thing.
My lord.
After this, your service was extended for another year.
My lord, agreement is there, my lord, at page 31. And but my lord, we are allowed to work.
There has to be something. This
Well,
this agreement is for the period up to 31st of March 2009.
31/3/2009, my lord.
So for 1 year.
Yes, my lord.
Was there any agreement thereafter?
Thereafter, my lord, no such agreement was executed. But my lord, as I have already submitted,
Hmm.
I was allowed to serve, my lord. And for that, my lord, I was paid regular salary. But the ground for termination of contractual agreement is, my lord, that there is some allegation against me regarding leakage of question paper of matriculation examination, my lord. Thereafter, I was arrested. Subsequently, I was released on bail. That order, lordship will find at page 40, passed by this honorable court,
Then what happened?
my lord.
Then what happened?
Then after that, my lord, we'll find the impugn order in the writ petition, that is at page 44. Yes, 44. Just around.
I'm sorry, my lord, I was on. My lord, what had happened? The learned single judge, my lord, has passed another order where a diametrically opposite view has been taken. Copy to the center. Huh? No, no, photo give the copy to that. My lord, can I place the copy of the honorable learned single judge, my lord?
Mr. Chaudhary, please come to page number 32.
31, my lord. Yes.
Read clause 9.
Non-disclosure of information, my lord.
Yes, please.
The contractual staff undertakes not to disclose, divulge, or make public, except on legal obligation, any information that he may acquire in course of his work without the written consent of the agency.
Then please come to clause 11.
Yes. Termination of contract. The agency reserves the right to terminate the contractual agreement at any point of time if it is found that the service rendered by contractual staff is not satisfactory, or if it is found that any declaration of information furnished by him or her proves to be false or willfully suppressed, or if there is any breach of any of the terms and conditions of his term of contractual engagement, or if the contractual staff is found to be involved in any act of indiscipline or misconduct, or if the contract staff is found to be involved in any act that may become embarrassing for the agency, or if the contractual staff is absent from job for 1 week without any prior written sanction, in case funds are not available under the administrative exigency, head from where remuneration are paid, the contract may be terminated forthwith without any notice. The decision of the agency in this regard shall be final and binding on the contractual staff and shall not be subject to challenge.
No, this is one. And secondly,
My lord,
your initial agreement was of 7th of March 2009.
yes.
So that
My lord, can I make one submission? My lord? These are there. Question is, the procedure which the authority has adopted to terminate my service.
Not on that. We are asking to clarification.
Yes.
The petitioner, the appellant herein is a contractual employee.
Yes, there is no dispute.
His contracts were extended every year.
Yes.
Now, from the order of bail, what we could see is that he was taken into custody on 12th of March, probably 17th of March.
Yes.
Now, 17th of March, he was arrested and then by order of
Released
bail,
on
he was
bail.
released on bail
Yes.
on 12th of May 2023.
Yes,
And by order dated 28th of March 2023,
yes,
the petitioner was terminated from
yes,
service.
yes,
Now, necessarily, his service would have been up to March some period because the initial contract was from 7th of March.
yes,
Now, when this petitioner was arrested
yes,
on 17th of March 2023,
yes.
was there any agreement between the petitioner and the authorities, the employer?
No, no,
And this is not the ground for dismissal.
Lordship is correct, no.
In that circumstances, when being a contractual employee,
Yes,
was he entitled for any such notice prior to his termination?
yes. Malad, that is the question. I'm absolutely obliged to your lordships. Malad, this point was,
1 o'clock.
oh, sorry, sorry.
It's okay. We'll come back, but
Yes.
too, we have a judgment.
Okay, little later, my lord.
Brother will also have a judgment.
My lord,
So,
in fact, it's a very interesting point, my lord. I would rather want your lordships to deal with it, my lord. Because lot many cases are depending on this case. In fact, today another case was there before the learned single judge, which said that we have preferred an appeal. Let it be taken up other, and so many other matters are also pending.
consider, come back at.
Yes, a little later at 2 o'clock, I'm already in midst of a partner matter. I'll take about 10-15 minutes, I'll come back.
Okay, no
Or
problem.
possibly by the time lordship can deliver the judgment.
In the meanwhile, we can take up the another, come back.
Okay, or my learned friend will start, I'll come and place the law, my friend.
Sorry.
Yes, Mr. Burman.
Next item is 942. Steps as directed by your lordship, I think it is complete.
We have served the copies to the railways, my lord, to the R.P. Dev Chaudhary. So his name may be shown.
Has not been shown.
So
Not been
official order is there about steps. My lord, railway was initially a pro forma respondent. They didn't appear before the single judge also. Now, as per your lordship's order, the same length of argument for interim and the entire matter will be required. So lordship will post the matter for my lord admission hearing sometime in June,
Also showing name of.
also showing name.
Mr. Borbora, your item is 40.
I have the caveator. This one. I was for the caveator sole respondent, my lord. I think there is an office note. Yes, come.
There are 9 of your lordship order, my lord.
Lordship recorded his preliminary submission and my preliminary submission, then about steps. Lordship directed it should be given to the additional Solicitor General.
Deputy Solicitor General, Mr. R.K. Dev Chaudhary. We have served 2 for 2.
Actually, it was written as petitioner, but and naturally the appellants have to serve copies, my lord. He served it.
Nature Singh, you have submitted?
Yes, yes.
Is there any receipt of, receipt of those copies?
Yes, ma'am. Actually, that was filed and it has been reflected as service notice.
Although it is written petitioner shall steps, it should have been, my lord, the appellant.
Heard Mr. B.K. Singh counsel appearing for the appellant. And Mr. A. Borbora, Learned Senior Counsel, assisted by whom?
My lord, and they.
And the, for the respondent number 1/aviator. Registry shall reflect the name of Deputy SGY, not by name. Deputy SGY for the respondent numbers 2 and 3, NF Railways.
They were, my lord, pro forma respondents. In the pro forma. They didn't come there. I don't think they are coming again here.
Registry shall list these matters after reflecting the name of Deputy SGY for the pro forma respondent number 2 and 3.
Detail about, do not.
After 2 weeks on a date to be fixed by.
So,
2 weeks by each.
So a date, my lord, it may be posted, my lord.
After 2 weeks.
After 2 weeks.
After 2 weeks, only date to be fixed by the registrar.
June,
18 number.
oh, my lord, it may be, my lord, in the second week of June, my lord, 10th,
2
11th,
weeks from
12th.
this, today it will become 2 weeks, second week only. We commencing from 10th. We commencing from 10th of June.
10th of June.
Awarded to the tune of rupees 3 lakhs, 3 lakhs, which is also agreed to by the state authority most probably. So, however, the identity of the person of the present petitioner is a bit disputed. So, we find that compensation will be payable to next of kin of the deceased, and that shall be deposited by the state authority before the learned district and session judge Dhemaji, who will obtaining the necessary report will just the money will be disbursed to the next kin of the deceased. So that is the procedure. So it will go to district and session judge Dhemaji, and it will be accordingly decided. And the state authority is ever directed to deposit the compensation amount of rupees to 3 lakhs within 2 months from the date of.
Because of Lucy Gold. What else of an 43 per month.
Item number 43.
May I please your lordship, on the last occasion, lordship directed us to obtain instruction as to whether there is any benevolent fund with regard to the police officials, especially with regard to the Tinsukia district lordship. To that extent, lordship, we have received one communication by the superintendent of police Tinsukia lordship. It is dated 21st of May. May I hand over a copy, which indicates that there is no such fund available in the district of Tinsukia lordship. Thereafter, we have also communicated with the Assam Police Headquarters lordship.
Is there any fund in the Assam Police headquarters?
They are also ascertaining they have not received any such papers from the superintendent of police. They require some more time. They have
No, but for the there is no benevolent fund account for the police personnel for Assam.
there is such fund lordship, but as because they have not received any, they have posed certain queries to the superintendent of police Tinsukia district. They have not received the answers regarding those questions. After receipt of those answers, they will be able to provide any such information. To my information, lordship, there is such fund, Assam Police Welfare Fund. There is such fund,
That
but
amount will be
specific
distributed, maybe distributed to the any such police personnel from any part of the Assam.
lordship.
Right.
Moreover, they have one more distress account fund also is available, wherein they get some help regarding their some critical illnesses, lordship, like cancer and such other critical diseases.
Pursuant to our inquiries. Mr. Rao, Common Advocate Assam. on instruction from the Superintendent of Police in Sukia, submitted that there is no corpus or benevolent fund account for the police personnel serving in Tinsukia district as such. On instruction, Mr. Talukder also submitted that the Assam Police as a whole has such distress account so as to help police personnel of Assam with regard to any such critical ailment for the police personnel or for employees,
Lordship,
their families.
more specifically, it is called, Lordship, Assam Police Central Distress Fund.
But namely Assam Police Central
Distress Fund.
Distress Fund. This will for the police personnel of Assam or also for their family members.
Lordship, perhaps it is in general, they receive.
Just like. On the next date fixed, the
We have communicated to Lordship AIGP law also. Additional Inspector General of Police law, Assam Police Headquarters.
Deputy Inspector General of Police Assam, as well as the additional Inspector General of Police within bracket law Assam, right?
Yes, Lordship.
Shall apprise the court of any such benevolent account for the police personnel, both serving as well as retired of Assam. Yes, Mr. Talukder, when?
Lordship may allow us 2 weeks time, Lord.
Okay.
They will coordinate in the meantime.
We'll have it on 24th,
Lordship,
placed on 24th of June.
may I ask for a copy of this order?
Copy of this order.
Obliged.
Yeah, legal laws.
Why is criminal appeal before this court?
My lord.
Okay. Wait for some time and see the bench might likely to be changed.
My lord, otherwise pleadings are completed. This matter will come up for hearing on next week. my lord.
We're not passing any order today. Wait for some time. Because normally it should go to the criminal bench. We're
Yes,
not,
my
that is not a regular bench.
Yes,
That's specially only entered with that. If not this week, the coming week, then week thereafter it will be a change.
My lord.
So automatically you can have that match. It is for, so we'll adjourn it for 2 weeks.
I do not.
Let it be like that. Okay, or a week will make it.
For a week, my lord.
Or lordship can direct it to be placed before the appropriate bench.
We'll make it different. On the prayer of the council for the party. Matter be adjourned for 10 days. Either of the parties may make a mention, is allowed to make mentions, allowed to mention before the appropriate bench.
Yeah, please, your lordship. My lord, notices were issued on this appeal. On respondents, the private respondents, the authorities of BPCL. 2 and 3 particularly,
And I am paying for BPCL, madam.
2 and 3 both, no?
You are appearing for whom? For BPCL, madam. 2 and 3, madam.
2 and 3. In-
Madam, dealt to similar case, madam, in the this is regarding the co-owner. Madam, co-owner has singly, madam, okay. Mr. Asbor Thakur, representing counsel for the Bharat Petroleum Corporation Limited has entered appearance on behalf of the respondent numbers 2 and 3. There is an interim order. Only one co-owner has executed the lease, that is the issue, madam. As such, service of notice is complete on all the respondents. Release this matter for admission on, give us a date. Next week, madam. 29th. Yes, ma'am.
Well, 29th, I have some difficulty, my lord.
38. Except 30 minutes. One.
My lord, actually 30th is in outlying bench, my lord, I will be there, that's why. Or 27th, if it that,
Yes, ma'am. 27 not possible. 31st.
31st.
31st. Yes, ma'am. Mr. Botter. Yes. So this matter is lordship relates to extension of interim order lordship. Dear lordship, due to some reason lordship, I could not appear before the SP order lordship in the time lordship. So, lordship, my friend took time lordship to file an affidavit.
Lordship, some instruction has been received, Lordship. And so many foreigners are absconding, Lordship, against them already affair has been lost, Lordship. And
No, so lordship, my humble prayer lordship. The lordship, he want to file affidavit lordship, he may file lordship, but I am in trouble lordship now, big trouble lordship. Because police lordship now behind me lordship. So lordship, even lordship, by imposing some cost lordship, I may be lordship allowed lordship to go on.
Nagaon, Lordship, 14 numbers of affair has been lost, Lordship. Again,
Yes, when will you file your affidavit?
Lordship, 1 week time may be allowed, Lordship.
On the prayer of Mr. G. Sharma, Standing Counsel, Home Department. Further, quick time is granted to the Commissioner Secretary, Home Department, Government of Assam, to file its affidavit. Pursuant to our earlier order dated 22/03/2024, placed on 10th June. Yes, Mr. Chaudhary.
Yes. Well, can I just give a few facts, my lord?
Sure.
The petitioner was appointed on 27/2/2009. 27th of February 2009. When I initially entered the service, my lord, I did sign a contract, but thereafter, my lord, there is no contract where I was put my signature. Then, my lord, in connection with a leak of question paper of my lord metric examination, the petitioner was arrested on 17/3/23. And on 12/5/23, my lord, the petitioner was released on bail.
Yes.
In the meantime, my lord, on 28/3/23, invoking clause 9 of the contract agreement, the petitioner was terminated from service. No notice, no inquiry, nothing. Now, my lord will kindly come to page 44, the impugn order which was challenged before the learned single judge. Page 44. Whereas it has been reported by CEO Dhemaji Jila Parishad, while later dated 21/3/23, that Sri Jan Soikia, computer assistant of Naharwari Gaon Panchayat under Bordolani Development Block, has been arrested on 17/3/23 in connection with CIDPS case number so-and-so, added section so-and-so, and he was in police custody for 4 days. The arrest and subsequent police custody of the employee has become embarrassing to the employer. In view of above, and in presence of clause 9 of the contract agreement, Sri Jan Soikia, computer assistant of Naharwari GP under Borolani Development Block, is hereby terminated with immediate effect. Now, these are the facts. Now, my lord, definitely the contract enables the employer to terminate the services of an employee if it is embarrassing to the employee. Now, my lord, what is the law on the point? Before I make my submission, my lord, I like to highlight one aspect within my humble submission is very important in this case. There are, my lord, thousands of such employees in the PNRD department, Government of Assam. Now, ideally, my lord, when money is being paid from consolidated fund of the state, the appointment should be, my lord, in pursuance of a rule framed under Article 309. Now, my lord, taking advantage of the, my lord, less bargaining power of the people seeking public employment, now, my lord, any mode of appointments are being resorted to. Normally, my lord, it should not be done, especially in a welfare state like ours. Ours is not a capitalist economy, my lord. We are a country where we are pursuing some social objectives. Now, having regard to this, my lord, when we come to the legal background or the legal principles enunciated by the Supreme Court, Lordship will see, even if the terms of contract permits somebody to terminate his service, but if termination is founded on some allegation, then an inquiry is a sine qua non. That is the law, my lord. Now, on that point, I will refer to that Purushottam Lal Dhingra's case.
See, in the same issue, there are two decisions.
Two decisions. In one issue, what I am saying today, that was been followed. In the other case, my lord, specific relief. Same honorable judge. And my lord, there is another judgment by another coordinate single judge that we have annexed, my lord, at page number 47.
You have read that.
Has your lordship seen that, my lord? My lord, if your lordship would kindly permit me to place that one paragraph from Purushottam Lal Dhingra, my lord, that will clarify the entire issue. That's in fact the first case on the point. The citation is 1958, AR 1958 Supreme Court, page 36.
Just a minute. Okay.
I will hear other judge.
Yes, please.
My lord will kindly come to para 28. The sentence starting with position may therefore be summed up as follows. Your lordship got it, my lord. Position may therefore be summed up as follows.
Please.
Has your lordship got it? Yes. My lord, somewhere in the middle, lordship will find a sentence starting with, but even if the government has by contract under the rules, about 15-20 lines below, my lord. But even if the government has by contract, has your lordship got it? Yes. But even if the government has by contract or under the rules, a right to terminate the employee without going through the procedure prescribed for inflicting punishment of dismissal or removal or reduction in rank, government may nevertheless choose to punish the servant. And if the termination of service is to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and requirement of Article 311 must be complied.
No, this, if the punishment is equivalent to any such punishment under 311, then notice must be given.
Well, in fact, Constitution bench judgment.
That's what the
Yes.
original judgment is there somewhere.
Yes, I brought that.
If it amounts to termination in
Yes.
service giving out.
In other words, if it is founded on allegation. Yes.
That's the law. Yes.
My lord, there is before that, if your lordship would kindly permit me to place one judgment, 1979 1 SCC 477. That is, my lord, the manager government press versus Beliappa. My lords will kindly come to para 19 of the judgment. 1979, 1 SCC 477. এটা কোনটো কোৱা আছে?
Yes,
It is now well settled. Has the lordship got it, my lord?
para,
Para 19, it is now well settled that the expression matters relating to employment.
yes, please.
Yes. It is now well settled that the expression matters relating to employment used in Article 61 is not confined to initial matters prior to the act of employment, but comprehends all matters in relation to employment, both prior and subsequent to employment, which are incidental to employment and form part of the terms and conditions of such employment, such as provision as to salary, increment, leave, gratuity, pension, age of superannuation, promotion, and even termination of employment. It is further well settled that Article 14, 15.1 and 16.1 form part of the same constitutional code of guarantee and supplement each other. So, my lord, guarantee under 16.1 is available not only at the time of entry into service, at different stages, including termination. Then, my lord, this Constitution Bench judgment, AIR 1963 SC 531.
Yeah, 196531.
Yes, AIR 1963 Supreme Court 531 is a Constitution Bench judgment, my lord.
Okay.
Same terms and conditions. Here it is contractual, there it was terminable contracts. Please come to the first para.
Which para?
Very first para, my lord, for the facts, same as ours. Appellant Madan Gopal was appointed an inspector of consolidation by an order dated 5th of October 53 of Settlement Commissioner of Patiala and East Punjab State Union. Appointment was temporary on temporary basis and terminable with 1 month's notice. Here also, my lord. Now, please come to paragraph 5. Para 4 also, my lord.
Yeah.
The appellant was a temporary employee and his employment was liable to be terminated by notice of 1 month without assigning any reason. Deputy Commissioner, however, did not act in exercise of this authority. Appellant was charged with a charge sheet setting out his misdemeanor, and inquiry was held in respect of an alleged misdemeanor and his employment was terminated because in view of the settlement officer with which the view of Deputy Commissioner agreed, misdemeanor was proved. Then 5. It is true that in case the court was dealing with the case of a public servant on probation, whereas the appellant was a temporary employee, but in principle it will make no difference whether the appellant was a probationer or a temporary employee. The appellant had been charged with a charge sheet and he had received illegal gratification from one person and had demanded illegal gratification from another. The appellant was given an opportunity to make his defense, and it appears that witnesses in support of the charge in deference were examined before the settlement officer. The settlement officer reported that on evidence he was satisfied that the appellant had received rupees 150 as illegal gratification and that the appellant did not enjoy good reputation and was a person of doubtful integrity. It is now well settled that protection of Article 311(2) of the Constitution applies as much to a temporary public servant as to a public servant. By virtue of Article 311 of the Constitution, the appellant was not liable to be dismissed or removed from service until he had been given a reasonable opportunity against the action proposed to be taken in regard to him. Appellant was given no such opportunity, and under Article 311 of the Constitution was therefore not complied with. Then, my lord, lordship's other point that regarding when it amounts to punishment, there my lord will kindly come to I'm sorry, focus. No?
Also probationer, if you put a temporary employee, if we still paragraph 3.
My lord, I'll place one judgment in the context of a probationer and one judgment in the context of a temporary employee. Now, 2005 SCC 152 in the context of probationer, but the principle is same, my lord. 2005 SCC 152.
This is provisional.
Probationer, my lord.
But right of provisional and right of contractual employees are little different.
No, my lord, end of the day, my lord, as I have already made my opening arguments, my lord, we have no bargaining power, my lord. Now, ideally, they should give us a substantive appointment because these are all preceded by selection. Now, even if I am contractual employee, I am a temporary employee, so I am right to protection. Para 28. It speaks about that motive and foundation, my lord.
Please.
Para 28. The important principles which are deducible on the concept of motive and foundation concerning a provisioner are that a provisioner has no right to hold the post and his service can be terminated at any time during or at the end of the period of provision on account of general unsuitability for the post in question. It is for the determination of suitability of the provisioner for the post in question or for his further retention in service or for confirmation, an inquiry is held and it is on the basis of that inquiry that a decision is taken to terminate his service. The order will not be punitive in nature. If, my lord, my credentials or my performance is being tested to find out to retain me in service or for confirmation, then this is not punitive. When it will be punitive, now it says. But if there are allegations of misconduct and an inquiry is held to find out the truth of that misconduct, an order terminating the service is passed on the basis of that inquiry, the order would be punitive in nature as the inquiry was held not for assessing the general suitability of the employee for the post in question, but to find out the truth of allegation of misconduct against the employee. In this situation, order would be founded on misconduct and not be a mere matter of motive. So if, my lord, at the moment allegation is taken note of, as has been pointed out in Purushottam Lal Dhingra, then, my lord, it attains the character of a dismissal, in which case 311 is attracted. Then, my lord, this 2001 10 SCC, it is in the context of a temporary employee. 2001 10 SCC 83. Paragraph 3. 2001 10 SCC, page 83.
Paragraph
3, my lord.
yes.
The legal position is fairly well settled that an order of termination of a temporary employee or a probationer or even a tenure employee, simpliciter without casting any stigma, may not be interfered with by the court. But court is not debarred from looking at the attending circumstances, namely the circumstances prior to issuance of the order of termination, to find out whether the alleged inefficiency really was the motive for the order of the termination or form foundation for the same order. If the court comes to a conclusion the order was in fact a motive, then obviously the order would not be interfered with. But if the court comes to a conclusion that the so-called inefficiency was the real foundation for passing the order of termination, then obviously such an order will be held to be penal in nature and must be interfered with, since the appropriate procedure has not been followed. Now, my lord, applying these principles to the facts of the present case, I was arrested in connection with some alleged offense. Now, merely because I was arrested, I may not be guilty. Tomorrow, my lord, if I am acquitted of the criminal charge, then my dismissal would be founded on some allegation. So then I am entitled to a notice. Then I am entitled to some sort of an inquiry. If not an inquiry, disciplinary inquiry, as we understand in the context of 311(2), at least some inquiry, my lord, some opportunity. That's why, my lord, in one of the case, Supreme Court has said, even if there is no prescription of notice, it is implicit, my lord. If your lordship will kindly have the judgment for a moment. 2004, 2 SCC 447. 2004, 2 SCC 447. My lords will kindly come to paragraph 10. The sentence starting with, even if a statute is silent.
Yes, please.
Even if a statute is silent and there are no positive words in the act or the rules made thereunder, there could be nothing wrong in spelling out the need to hear the parties whose rights and interests are likely to be affected by orders that may be passed, and making it a requirement to follow a fair procedure before taking a decision, unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute, unless there is a clear mandate to the contrary. No form or procedure should ever be permitted to exclude the presentation of litigants' defense or the stand. Even in the absence of a provision in procedural law, power inheres in every tribunal court of judicial or quasi-judicial character to adopt modalities necessary to achieve the requirement of natural justice and fair play to ensure better and proper discharge of their duties. Procedure is mainly grounded on the principle of natural justice, irrespective of the extent to its application by express provision in that regard in a given situation. It has always been cherished principle where statute is silent about the observance of principles of natural justice. Such statutory silence is taken to imply compliance with the principles of natural justice, where substantial rights of parties are considerably affected. In fact, my lord, if your lordship should recollect that famous case of Binapani Devi, Orissa case, my lord, if an action has an adverse consequence, it must be passed in consonance with the principles of natural justice. Now, my lord, please come to the judgment of the learned single judge in the other matter. My lord, that Binapani Devi judgment we have brought, that is, my lord, AIR 1967 Supreme Court 1269. AIR 1967 Supreme Court 1269, para 9. Okay, that is a well-quoted judgment, my lord. If your lordship would kindly have the judgment,
Page 52.
Now, if your lordship would kindly have the judgment of in the 4266 of 23, my lord, please come to para 8. The facts of this case. Here a show cause notice was also issued. Commissioner PNRD Department by the show cause notice dated 6/5/23 provided an inquiry report to the petitioner and directed the petitioner to submit a written explanation as to why his service should not be terminated
as per the terms and conditions of the contractual agreement, which amounts to gross indiscipline as well as gross negligence of duty and misconduct on his part. Petitioner had filed a show cause reply dated so and so, which was not found satisfactory by the competent authority, and by office order dated 13/7/23, the service of the petitioner was terminated with immediate effect. The learned senior counsel for the petitioner had submitted that the impugn order dated 13/7/23 does not disclose that any departmental proceeding was initiated against the petitioner and that he was given an opportunity of hearing or if any memorandum of charges were framed against him. Accordingly, it is submitted, procedure prescribed under 1964 rule has not been followed. The learned counsel for the PNRD department has submitted that now this is important, was a contractual employee, there is no requirement of giving opportunity of oral hearing, and providing the petitioner with a copy of the inquiry report was sufficient compliance of the principles of natural justice. In support of his contention, the oral hearing was not necessary. The learned counsel for the PNRD department has cited. So this was the specific case, my lord, that it is a contractual appointment, therefore is not entitled to anything. Now please come to para 15. At page 7. It is too well settled that even in case of a temporary appointment, the principles of natural justice cannot be altogether abandoned. In the present case in hand, nature of accusation against the petitioner is stigmatic, as there is a specific allegation against the petitioner of gross negligence of duty and misappropriation of government money with malafide intention, which appears from the show cause notice to the petitioner dated so and so. It would have been a different matter if authorities would have chosen not to renew the contract. However, in this case, Commissioner PWD had issued show cause notice to the petitioner, which contains stigmatic allegation against the petitioner. So these are the recital of facts, my lord. Now, my lord will kindly come to para 19. Now, Purushottam Lal Dhingra is pressed into service. In the light of the allegations on which the service of the petitioner has been terminated, the Supreme Court of India, in case of Purushottam Lal Dhingra, reported in so has already held. I'm sorry, my lord. Page 9, para 19. Your lordship's got it, my lord. Yes. In the light of the allegation on which service of the petitioner has been terminated, the Honorable Supreme Court of India, in case of Purushottam Lal Dhingra, reported in has already held that even for terminating a temporary employee, the principles of Article 309 of the Constitution was required to be complied with. Similar view of the Supreme Court has also been expressed in so and so, wherein it is reiterated that termination of service of temporary government servant without any stigma would amount to punishment which may not be made without inquiry. However, it is specifically held that even as temporary government servant, delinquent is entitled to protection under Article 11 of the Constitution of India, where the termination involves stigma or amounts to punishment. Therefore, the two cases cited by the learned counsel for the respondent do not help to espouse the cause of the respondent, as this case is found to be similarly situated with the facts in Ali Ahmed Bormia. Accordingly, this court is inclined to hold that merely providing of inquiry report to the petitioner at the stage of issuing show cause notice is not sufficient compliance of the principles of natural justice. And as the service of the petitioner was sought to be terminated on the ground of gross irregularity and misappropriation of government fund, the petitioner is found to be entitled to be given an opportunity of being heard, as the nature of stigma attached in the impugn order dated, apart from being stigmatic, is likely to cause serious prejudice to the petitioner in future prospect and government opportunities. So, my lord, having taken this view, same set of facts, same panchayat employee, same job, same post. Therefore, my humble submission is, my lord, and moreover, my lord, this judgment is par inferior, my lord. The judgment which is under challenge in this case. In fact, prior to that judgment, the judgment at page 47 was already there. This Ali Ahmed, this very Ali Ahmed Borgwe has been followed, my lord. If your lordship would kindly come to page 49. Sorry, 50. No, 49. 49, my lord. This third subpara. It is no doubt correct that in case of a contractual engagement, the terms and conditions of the contract would govern by the service conditions of the employee. In the present case, the contract agreement signed by the petitioner does not have a clause permitting termination of the contract at any point of time if the service rendered by the contractual staff was found to be not found to be satisfactory. However, what is to be noted herein, that bare perusal of the impugned order of termination demonstrates on the face of the record. The same was issued on the basis of findings of the inquiry proceeding conducted behind the back of the petitioner, wherein it had been projected that petitioner was guilty. Therefore, the order of termination of service of the petitioner dated 30/10/21 is not only based on allegation of misconduct, but same is also stigmatic on the face of the records. In other words, the impugned order of termination was founded on allegation of misconduct. However, petitioner was not given any opportunity of being heard in the matter. Therefore, it is a case where respondents have acted in violation of the principles of natural justice. The order of termination from service issued to the petitioner has the trappings of an order of dismissal, removal from service. Therefore, such an order would not have been issued without giving employee an opportunity of being heard, even if the same pertains to temporary or contractual employee. This is for the simple reason that such an action, besides causing serious prejudice to the interest of the employee, would also have a bearing on the prospect of his future employment. Situated thus, this court is of the unhesitant opinion that order of termination dated is unsustainable in the eye of law. Therefore, the same is set aside. Now, this is important. The respondents are directed to reinstate the petitioner back in service within 10 days from the date of receipt of the certified copy of this order. After reinstatement of the petitioner, it would be open for the respondents to proceed against him in accordance with law by serving proper notice indicating specific charges brought against the petitioner. In doing so, it would also be open to the department to place the petitioner under suspension pending trial of the conclusion of the proceedings, if so advised. However, in such an event, petitioner will be paid subsistence allowance. F number. Wait. Therefore, my humble submission is, my lord. Huh? So therefore, my humble submission is, my lord.
Yes, please tell us one thing. Please come to page number 44.
Can I take leave for 10 minutes?
Yes. Read slowly.
My lord. Whereas it has been reported by the CEO, Dhemaji Zilla Parishad, by WT message letter number so and so, dated 21/3/2023, that Sri Jan Saikia, computer assistant of Nahorbari GP under Bordolani Development Block, District Dhemaji, Assam, has been arrested on 17/3/2023 in connection with CID PS case number so and so under section so and so IPC so and so at added section so and so, and he was in police custody in 4 days. The arrest and subsequent police custody of the employee has become embarrassing to the employer. In view of the above and in pursuance of clause 9 of the contract agreement, Sri Jan Sekia, computer assistant of Naharbari ZP under Bordolani Development Block, District Dhemaji, is hereby terminated with immediate effect. In lieu of notice and in view of the circumstances, 1 month's salary is to be paid to the concerned employee.
Now, reading this order,
My lord.
please tell us whether it is stigmatic or not.
Yes, my lord.
In my understanding, my lord, it's not stigmatic, my lord,
It's not stigma.
not stigmatic. It's only the arrest of the petitioner, my lord, appellant, is only the motive to termination or of the termination, my lord, not foundation, my lord. Because
The
that inquiry was not
arrest-
done by department, my lord,
The arrest and subsequent police custody
my lord.
of the employee has been embracing to the employer.
Yes, that is a clause of our tender agreement, my lord. Lordship may kindly come to page number 32, the clause, my lord. And the arrest, my lord, it's the fact, my lord. It's not the allegation, my lord. It's a fact.
Why you have decided to terminate him?
My lord, as because, my
No,
lord,
tell us. Why you have decided to terminate him being a contractual? If you could have relieved him, you could have, we could not have extended the contract.
yes, my lord. This
If you have terminated him on the ground that because of his act was embarrassment for you,
my lord,
for the employer,
my lord,
then it will be stigma.
my lord, in that query, my lord, I'll submit, my
Could have
lord.
relieved him, we could not have extended the agreement.
This termination word, my lord, is meaning, my lord, the agreement termination, my lord, actually, my lord.
We do not know. That is not your strength. Terminated from service. He is hereby terminated. If
May I
you
cite,
want that,
may I
it is
cite some
you are
reasoning,
saying.
my lord? May I cite
In
some?
view of the above and in pursuant of clause 9 of the contract agreement, Sri Chandrasekhar, competent assistant of Nahorbadi Gram Panchayat under Bordolin Development Block District Dhemaji is hereby terminated. Who is terminated? The person concerned is
Yes.
terminated with immediate effect.
I'll say, my lord, that it is
His
termination
contract-
simpliciter, my lord. For that, my lord, notice is not required, my lord.
See, basically, you are the employer. You have decided instead of terminating his service, could have kept quiet, could have asked from asking him not to come automatically because his agreement was not there at that point of time when you
Yes.
have issued that. We have been finished.
Yes, my lord.
And at that point of time, he was in jail also.
Yes,
He was released subsequently in month of May.
my lord,
Right.
my lord.
So
My lord, just one clause, my lord. That clause, may I read, my lord, once again? Page 32, my lord. Yes. Termination of contract. The agency reserves the right to terminate the contractual agreement at any point of time if it is found that the services rendered by the contractual staff is not satisfactory, or if it is found that any declaration of information furnished by him or her proves to be false or willfully suppressed, or if there is any breach of any of the term and condition of this term of contractual engagement, or if the contractual staff is found to be involved in any act of indiscipline or misconduct, or if the contractual staff is found to be involved in any act that may become embarrassing for the agency, or if the contractual staff is absent from job for 1 week without any prior written sanction. In case funds are not available under the administrative contingency head from where the remuneration are paid, the contract may be terminated forthwith without any notice. So
Now,
the
here-
word is terminated, my lord,
No,
in this
please.
clause. Now, my lord, the impugn order, my lord, here, my lord, the first part is the fact, my lord, that he was arrested. That is admitted, my lord. And as the clause, these employees' service is governed by their contract only, my lord. There are no service rules. So, as per the clause, we can terminate him without notice, my lord. And this is not stigmatic, my lord. And to support that, my lord, I am citing some judgments, my lord.
just
Whether-
tell us to arrive at a decision
My lord.
that the conduct of the staff is found to be involved in is embracing the employer.
Yes.
How will you prove it?
My lord, because he admittedly arrested, my lord.
A person is arrested, many big persons, IS officers, forest officers arrested.
If, my
They are
lord,
acquitted later, they got gets back their job. Why?
because,
Because it
my
has
lord,
to be
they were
proven.
under protected under 311, my lord. In this
That
case,
is the
it is
reason we
under
are asking
protection,
you.
my lord.
What is there? In case, okay, then in case this is right.
Hmm.
The contract may be terminated forthwith without
Yes.
any notice.
Yes, my lord.
Now reading this order of termination of the service of the
My lord.
petitioner,
My
you
lord.
read it again and tell us. It is the termination of the contract or termination of the person is number 44.
In view of the above, in persons of clause 9 of the contract agreement, she Kya, so and so under so and so is hereby terminated with immediate effect, my lord.
He is terminated,
My
not the
lord.
contract.
My lord.
The language should have been different in that case
Yes, my lord.
altogether.
This is technical, my lord.
It is not technical, it is pure. You are aggrieved by the conduct of the petitioner,
Yes,
the
my lord.
appellant here.
My lord.
So you said you are embarrassed by his arrest and his action
My lord.
without coming to any finality, right?
Yes, my
Is there any charge sheet against him?
lord. That is not.
It is also not there.
Not yet.
Then
But question before lords is, my lord, whether we can terminate as
you
termination
can
simpliciter,
you
my
can
lord.
terminate the agreement, right?
Yes, my lord. Whether we have the right to terminate as a termination simpliciter, that is the question before your lordships, my lord. To satisfy that, my lord, I want to cite some judgments, my lord. May I please, my lord?
Just a minute. Just
My
a
lord, my lord. My lord, could you please admit it, huh? Mhm. Like it is, yeah, okay, terminate probably.
please take your seat.
Well, one more submission can I make, my lord? The page 49, they have referred one judgment, my lord. And this judgment is not similar to our case, my lord. Because lordship may kindly come to 49 again. The fourth paragraph, my lord, it starts from it is no doubt. Then fifth line, however, my lord. However, what is to be noted here in that bare perusal of the impugn order of termination demonstrates on the face of the record that the same was issued on the basis of findings of the inquiry proceeding conducted behind the back of the petitioner, wherein it has been projected that the petitioner was guilty of misconduct, my lord. Therefore, the order of termination of service of the petitioner dated so and so is not only based on allegation of misconduct, but the same is also stigmatic on the face of the record, my lord. So in that case, my lord, in the termination order itself, my lord, we have made some allegations of misconduct, my lord. So that was the foundation of the termination order, and honorable single judge, my lord, set aside that order, my lord. In present case, my lord, this is only the motive, my lord, not the foundation. The subsequent arrest of that petitioner, my lord, is the motive of the termination of the order. Of clause 11, we have the power to terminate him, my lord. More paragraph not recorded. No. No. Kita boleh ni. Yes, yes. Yes, duration of contract. My lord. The engagement shall be purely on contract basis for the period as mentioned in the order of contractual engagement unless terminated earlier. The service of the contractual staff shall stand automatically terminated at the expiry of the contract period unless yes. Earlier. Yes. Earlier. Yes. Yes, ma'am. Uh, yes, my lord. And the services of the contractual staff shall stand automatically terminated at the expiry of the contract period unless terminated earlier without any necessity of the agency giving any notice to the contractual staff and without any liability on the part of the agency to pay any retrenchment or other compensation or other amounts to the contractual staff. The contractual, yeah. My lord. Yes. My lord. Yes. My lord. My lord. Right. My lord. My lord. Yes, my lord. My lord. Yes. Yes, my lord. My lord. My lord. My lord. My lord. That is always there, my lord. Yes. My lord. My lord. My lord. The my lord. My my lord. My lord. My lord, my lord. My lord. My lord. My lord. Yes, my lord. My lord. My lord, in this present case, my lord, the termination was expired in the year 2009 itself. Yes. My lord. Yes, my lord. My lord. Although there was no. Yes, yes. That part we are not disputing, my lord. My lord. My lord. My lord. My lord. In that case also, my lord, March 2024, contract is over, my lord. Because yes, my lord. That is my point, my lord. That order is stigmatic or not. My lord, lordship may kindly. Yes, my lord. Lordship may kindly. My lord, lordship. As per contractual term, my lord, there is already agreed term. My lord, the 11 termination, the contract clause 11, my lord. My lord. My lord. Yes. The arrest, my lord, the involvement, my lord. Lordship may kindly go through the judgments I have cited, my lord. I have given 2 sets, my lord. As the allegation of yes, my lord. Yes. 311. Yes. My lord. Not, my lord. Yes, my lord. Because the Assam. My lord. The agreement. Yes, my lord. My lord, in that case, my lord, the Assam disciplinary. No. The Assam Service Discipline and Appeal Rules, my lord, saying, my lord, section 3, rule 3, my lord, the application. These rules cells apply to all government servants except person in casual employment, my lord. And these contractual employees are casual, my lord, in nature, my lord. So these rules are some disciplinary appeal rules will not applicable for the contractual employees. Those employees, my lord, we does not have any service rule. So only governing thing is the contract, my lord. That is, my lord. That is clause is saying that. Clause 11 is saying, my lord. I'm reading again, my lord. Page 32. Page 32, my lord. The agency reserves the right to terminate the contractual agreement at any point of time if it is found that the services rendered by the contractual staff is not satisfactory, or if it is found that any declaration of information furnished by him, her, proves to be false or willfully suppressed, or if there is any breach of any of the terms and conditions of this term of contractual engagement, or if the contractual staff is found to be involved in any act of indiscipline or misconduct, or if the contractual staff is found to be involved in any act that may become embarrassing for the agency. So first, he was a computer operator, my lord, in a Dhemaji district, my lord. Naharani, yes, my lord. Gaon Panchayat, yes. PNRD department, my lord. My lord. My lord, 37, my lord. The Additional Director General of Police, CID, so and so. Investigation regarding handwritten question paper of General Science, subject of HSLC examination 2023. Sir, I have the honor to inform you that a news is telecast in a section of media today evening that a handwritten model question paper of HSLC examination of General Science C3 subject, which is to be held on 13th March 2023, Monday, is available in the hands of some candidates. And it is also spread in the social media. We have examined the contents of the handwritten question paper and found some similarity with the question paper by the Board of Secondary Education, Assam, SEBA. Therefore, the examination of General Science subject, which is to be held on 13 March 2023 Monday, is cancelled. This is very possibility of leakage of the question paper of General Science subject from the storage of the same at some place. The copies of handwritten question paper as telecast are also enclosed herewith. I therefore request you to investigate the matter to apprehend the culprit. No, his allegation is that, my lord, he forwarded, my lord, the handwritten paper to 4 or 5 peoples, my lord. Yes. Yes, and those were, my lord, the students, beneficiaries, my lord. We are not on the merit of that criminal case, my lord. My lord. Maybe, my lord, maybe. My lord. My lord. Yes. My lord, I will not comment on any merit of that criminal case, my lord, because it will also go on there also. My lord. My lord. Maybe, my lord. My lord. Yes, my lord. That is admitted, my lord, and I will not go to that, my lord. So my submissions is that, my lord, that whether the question before loss is whether this is stigmatic or not, my lord. My lord. Maybe, yes, my lord. Yes. Whether from any, yes. My lord. My lord. My lord. My lord, to justify my points, my lord, kindly allow me to read my judgments, my lord. Right. I've given 2 sides, my lord. In the one paper, my lord, I have quoted the main relevant paragraphs, my lord. First, my lord, 2004 11 SCC 743, the state of Punjab versus Balbir Singh. Paragraph 5. Does the order of discharge simpliciter prima facie is not punitive, it being in terms of Punjab police rule so and so. In that case, they have some rules, my lord. But the question still is whether the incident which led to the passing of that order was motive or inducing factor, or was the foundation of the order of discharge. Paragraph 6, my lord. Paragraph 6. The test to determine whether the misconduct is motive or the foundation of an order of discharge was laid down after exhaustively dealing with the case law on the topic. In the case of Radhesham Gupta versus UP State Agro Industries Corporation Limited, so and so, as follows up. Paragraph 13. It will be noticed from the above decisions that the termination of the services of a temporary servant or one on probation on the basis of adverse entries or on the basis of an assessment that his work is not satisfactory will not be punitive, inasmuch as the above facts are merely the motive and not the foundation. The reason why they are the motive is that the assessment is not done with the object of finding out any misconduct of the part of the officer, as stated by so and so in so and so. Next page, my lord. It is done only with a view to decide whether he is to be retained or continued in service. The position is not different even if a preliminary inquiry is held, because the purpose of a preliminary inquiry is to find out if there is prima facie evidence or materials to initiate a regular departmental inquiry. It has been so decided in Champaklal case, so and so. The purpose of the preliminary inquiry is not to find out the misconduct on the part of the officer, and if a termination follows without giving an opportunity, it will not be bad. Even in a case whether a regular departmental proceeding inquiry is started, a charge memo issued, reply obtained, and an inquiry officer is appointed, if at that point of time the inquiry is dropped and a simple notice of termination is passed, the same will not be punitive, because the inquiry officer has not recorded evidence nor given any findings on the charges. That is what held in Sukhraj Bahadur case. So and so. In the latter case, the departmental inquiry was stopped because the employer was not sure of establishing the guilt of the employee. In all these cases, the allegations against the employee merely raised a cloud on his conduct, and a pointed by Krishna Iyer judge in Gujarat Steel Tubes case. The employer was entitled to say that he would not continue an employee against whom allegations were made. The truth or which the employer was not interested to ascertain. In fact, the employer, by opting to pass a simple order of termination as permitted by the terms of the appointment or as permitted by the rules, was conferring a benefit on the employee by passing a simple order of termination, so that the employee would not suffer from any stigma which would attach to the rest of his career if a dismissal or other punitive order was passed. The above are all examples where the allegations whose truth has not been found and were merely the motive, my lord. In the present case also, we have not found the truth, whether he was involved or not. We have really terminated him simpliciter, my lord. To paragraph 34. But in cases where the termination is preceded by an inquiry and evidence is received and findings as to misconduct of a definite nature and arrived at behind the back of the officer, and where on the basis of such a report the termination order is issued, such an order will be violative of principle of natural justice, in as much as the purpose of the inquiry is to find out the truth of the allegation with a view to punish him, and not merely to gather evidence for a future regular departmental inquiry. In such cases, the termination is to be treated as based or founded upon misconduct and will be punitive. These are obviously not cases where the employer feels that there is a mere cloud against the employee's conduct, but are cases where the employer has virtually accepted the definitive and clear findings of the inquiry officer, which are all arrived at behind the back of the employee, even though such acceptance of finding is not recorded in the order of termination. that is why the misconduct is foundation and not merely the motive in such cases. Paragraph 7. Does the principle that in order to determine whether the misconduct is motive or foundation of order of termination, the test to be applied is to ask the question as to what was the object of the inquiry. If an inquiry or an assessment is done with the object of finding out any misconduct on the part of the employee, and for that reason his services are terminated, then it would be punitive in nature. On the other hand, if such an inquiry or an assessment is aimed at determining the suitability of an employee for a particular job, such termination would be termination simpliciter and not punitive in nature. Yes, yes, my lord. In fact, one single judge's bench judgment is also there, my lord. Hmm? Ajay Kumar alert. Ajay Kumar alert. Ajay Kumar alert. WPC 854/2011. Citation पे लिखा नहीं मानव पत्र. WPC 854/2011. my lord. The clause 2 is also there, my lord. In the duration of contract, in the last part, my lord. The contract may be also be terminated without assigning any reason before the contract period by either party, subject to giving 1 month's advance notice to the other party. Oh, that 1 month salary part is also there, my lord. Hmm? Actually, what happened, my lord? This agreement, my lord, was the old one, my lord, from 2009. Now, my lord, presently the model agreement is a little bit different from this agreement. This agreement was already expired and not existing, my lord. No, my lord, that was dismissed on the very motion day, first day, my lord. So our stand is not recorded directly, my lord. Who has not given opportunity, my lord. My lord. My lord. That part I'll not. No. That as the case is already dismissed, so we are not raising that. Not that point when it is maybe more from bonus, my lord. Bonus to the yes, my lord. My lord. My lord, for that reason, my technical point, my lord, is for that reason, my lord, that order, my lord, because
This one, since my learned friend has already submitted, there is no such contract agreement as on date. And the impugn order has been passed on the basis of that agreement, which doesn't exist. So it's a.
that issue I'm not raising, my lord, because I'm only submitting on law points, my lord.
But the very basis is the terms and conditions of that contract agreement, which according to my friend is not in existence.
They're
So
very happy to go back.
on this ground, my lord, in my humble submission, the impugn judgment may be set aside, my lord.
Hmm? 1 month salary কথা ক'ত লিখে? Notice দিয়াৰ কথাই আছে। 1 month notice দিয়াৰ কথা আছে, not 1 month salary। এইটো ক'ত লিখা আছে ইয়াতে নাই ন। এইটো কথা কোৱা নাই, এইটো কথা কোৱা নাই। তাৰপিছত 1 মাহৰ against যে project লিখা থাকে, সেইটো কিন্তু লিখা থাকে normal, এইখনত নাই। এই বস্তুটো লেখা নাই এইটো কথা প্ৰত্যেক কৰিব ইয়াৰ মতে হ'ব চব প্ৰত্যেকটো বস্তু আমি পইচা দিলোঁ সেইটো কৈছোঁ সেইটো ক'ত লিখা যাবে My lord, I am just, my lord, if lordship will allow this writ appeal, my lord, there are numbers of cases pending, and in those cases, my lord, there are some lots of allegations in the department also. Without we are, and all the cases are waiting only for this case, my lord, because they were also their main. That case is not similar to us, our case, my lord. Because in that case, my lord, there are specific allegations of misconduct in the department itself. But in our cases, although some allegations are there, but we have not mentioned in any termination order, my lord. Where simpliciter we have released. Or in some cases, my lord, they were arrested. My lord, our right is the clause, standard clause, my lord. Yes, yes, my lord. This is a tender clause provision, my lord. We can release him, my lord. Serving not legally, but he has somehow. Because he is not directly in the department he is working. These are schemes, my lord. These are under scheme he is working. Rega scheme. Then there are other schemes, my lord. Some Rega schemes, then some different schemes. Those they are. No. This is not mentioned.
The impugn order was passed by the Commissioner, Panchayat and Rural
Yes.
Development Department, my lord. That means we are the employees of contractual
Yes,
employee under that department.
Panchayat
That
department
why
is
this
the
order was passed.
nodal department, my lord. Nodal department. Because these employees are governed by the commissionerate, my lord. The nodal department is Panchayat, my lord. Yes, yes. But not this employee, not only specifically Rega, my lord. These are contractual employees for two, my lord. So my humble, my lord, my humble submission is that, my lord, that the earlier cases were different from this case, my lord. Therefore, not applicable. And we have the right to terminate, my lord, because it's a simpliciter, not as per the motive we have terminated, not the foundation, my lord. The arrest of the petitioner is a fact, my lord, and thereafter only, as per clause 11, we have terminated, my lord. So I have referred some cases. Those cases are exactly on my point, my lord. The authority, the apex court is supporting my submissions, my lord, in those cases, my lord. That is my submission, my lord. Lordship will consider, my lord.
There are instances in the Panchayat department, my lord. There are some contractual employees similarly placed. They were arrested. After they released on bail, the notice was issued to them. They submitted their reply, and the reply was found to be not satisfactory. On that ground, they were terminated. Those termination orders were put to challenge before this honorable court. This honorable court was pleased to set aside those orders with a direction. Since you issue a notice, you have to bring the so-called logical. About that, my lord.
Yes, my lord.
Contractually.
I'll, my,
And five judgments are there. My lord. Yes. May I read, my lord? Nine. My lord.
my lord, the health department. My lord. Yes, you know. Yes, 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 okay, yes. It transfer, yes. 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 I will ask good. Yes. 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 And my lord, one point is there, my lord, that the contract agreement is not in existence as submitted by my friend. So it may.
Yes.
Yes. When is that due, my lord? PNRD department, yes.
That
yes.
part we are not disputing also, my lord. My lord. First. Yes, five, yes. Also six, my lord. Six, I am appearing, my lord. Three also, my lord. Oh, yes, yes.
My lord. Lots of weird matter with length, my lord. It may take us further, my lord. All the hearing is done, my lord. We are deeply obliged, lordship.
Lordship, in item number 45, there is an interim. Kindly continue this. Kindly continue.
Obliged.
Conditional will be granted.
I'm deeply obliged.
Ever it is sounding to other. Hey, ora. How do you say it? The order to solve,